Okay, well, that'll streamline that one. Okay, and you are?
Attorney here, Sasha.
Good morning.
Okay. But that's the only one you've got?
Yes.
Okay.
Oh, yeah, a little nervous this morning. Could it be the end? Could today be the end of the first YSL RICO trial? When I say end, Shannon and Yak, they get out. Today might be the end. Good morning, everybody. Good morning, everybody. I'm so sorry I'm late, y'all. I was up late braiding hair. Again, why they always got me up braiding hair? Why? I was up last night. I had to do some boho knotless on my niece, y'all. So sorry I'm late, but I'm here. Good morning, Crystal. Good morning, Isis, Jennifer. I see Megan, Georgette. Hey, Lisa. Hey, Aisha. Who else on here? Hey, Lakeisha. Hey, Jazz. Hey, Jade. Hey, Princess. Hey, kid girl. Hey, pretty. Yes, y'all, we here. Hey, Shawnee. Hey, Camilla. Isis, will they stop? I just don't wait anymore. Okay. Hey, Taylor. Hey, Jen. Hey, Chelsea. Hey, Chiquita. Hey, Kenzie. Miss Hey, Lisa. Yeah, I don't want to be brain here all day, okay? But I did some more list last night. Hey, Kiara. Hey, Jasmine. Hey, Armana. Hey, Erica. Roll Dog. Hey, friend. Hey, Tam. Who y'all these dogs? Hey, Adrian. I don't see Kaylin. Oh, Lord. Adam. Is that Adam? Hey, Shani. Thank you, kids. Hey, Max. Don't
Will Mr. Rao be able to stay? Will you be able to stay here if Mr. Abate has to go to 1C, or you guys are here?
I'm sure we can tag him.
Okay.
Yeah, he can stay out later.
Who is that?
Okay.
It's Leah.
We'll see. Currently, we have no defendants.
Yeah.
Yeah, how long is this gonna be?
Mr. Mersajan, do you have a colleague who will be covering? We have 10 bond hearings, and in reviewing them last night, a number of them look like they would be appointed counsel. I know there's going to be one conflict issue because it's co-defendants, but I'm surprised you have only one.
Okay, let me turn him down. It's a lot of Kiara's in the chat today. It's a lot of Kiaras in the chat today. So, hey, to all the Kiaras, I swear I have spoken to at least 4 Kiaras today. Hey, Ash. Oh, Ash. Lord Jesus. Well, I think I'm hoping he is. Hold on, y'all.
And you're lucky if that person
is already. I have, but I don't have it together. Uh-oh.
Mr. Beatty hired private counsel, as I understand, so I was going to get from Powell.
Okay, yeah, I was trying to stop him. So Shannon's is a negotiated plea. Should be nothing too much. Yak's is the only one. We actually, we need to be sending up a few prayers for him, which I definitely have prayed for him. I want Yak to get out of this. I need Yak to go back to making music like in a coupe, okay? This is for Yak, y'all. So this is so that he can get probation. I mean, not probation, Lord Jesus, so that he can get bond.
And assigned to Judge Leffridge. So we will not be hearing bond for Mr. Washington today. What was the other one? Daryl Williams. I got that one. And you are? Can you say your last name again? Isola. How would you spell that? Okay. So once Mr. Williams is up, we'll try to do that one. Judge Leffridge. So that won't be heard today. That's just, he's been indicted. And so any issues or questions about bond will be covered by Judge Leffridge, to whom his case was assigned. So I don't even think he was brought over today. He may have been, but I won't be addressing bond because it's now assigned to a judge. Good morning, Ms. Clark.
Morning, Your Honor.
So you'll be handling the bond hearing for, assuming we get lawyers, for Kuykendall and McCaslin,
Yes, Your Honor.
as well as Mr. Tevis's client.
Tyreek
Yes.
Robinson.
Yes.
Yeah, I think the do not record is for Zoom, people that are on Zoom, because when you're on YouTube, if you can record, they have a Rule 22 for this. So I just, yeah. It says this on, let me make him quiet. I've actually seen the do not record, that little thing on all of the Zooms. And I think it's a Zoom thing. They're telling people don't record on the Zooms. I think it's a Zoom thing because the other lawyer in the case with Fonnie Willis, hers had that too, but I think it's a Zoom rule. Like, they're not talking about streaming, they're putting it on YouTube. So clearly it's okay to record, right? It's not a private matter. But yeah, I saw that on hers too. You know what, Jay? Get off the live right now. Get off the live right now.
Pardon me?
I didn't receive a calendar for this date. I don't know about it because I looked up my concept, obviously. So I get a calendar for that to the splits.
Okay, let me get you a calendar. Ms. Nelson, can you text me to whom you sent the presiding bond calendar on the public defender side? Because it sounded like it might not have gotten over there.
I went to our team, and so
Meaning-
it didn't go to any private attorney. I mean, it didn't go to the public defender's main office. It went to our team.
Yes, it's Max.
Meaning it went to Ms. Rios and Ms. Wood.
Was Max.
Correct.
Okay, I'll print you one.
And additionally,
I got an extra copy.
Of the bond calendar? Great, here it comes.
additionally, I did not file a bond motion for this hearing today, so that also need to be why other public defender attorneys are not aware or not here.
Huh.
This
Well, we shouldn't be calendaring things where there aren't bond motions. We're gonna need to work on our process.
Oh, I
My
know this.
client has only been in custody for about 20 days and telling me that.
Well, that's what all these are, though. These are the ones where there was a bond deferral. So at first appearance, because of your client's charges, murder, and all these other folks, with one exception where it's a child sex offense or a rape or something, they're all murder cases. And so they never got a crack at a bond hearing. And so we automatically put them on these calendars. But you can say no thank you at this point. There's not a mandatory bond hearing.
Yes, sir, that was my plan to, well, not exactly withdraw the motion, but say we're not ready for a home hearing this time.
Okay,
Mr. Powell, yeah.
okay,
And I will reach out to the other attorneys and figure out.
okay. So I should take Powell off because you don't want to go forward with bond today. It'll stay with me. It's until indicted, bond hearing will be here. So if you want to defer the bond hearing to another day, that's good to know. I just want to make that notation.
Yes, sir, that's my.
Okay, thanks.
Oh, Jasmine, you got jokes this morning. Oh, okay. Jasmine got jokes. She thought that was me sitting by Miss Tasha.
Yeah.
Jasmine got jokes early. Maybe it's 9:19.
But that may make it go more quickly. Right. Okay.
Maybe.
All right, so if there was anyone here for Mr. Powell and the deceased in that case is Mr. Woods, we're not going forward with that hearing today.
Okay.
and we'll see what other announcements we get.
Hey, booty. Jasmine said she been up since 5. She ready. Don't come here on that BS. And I hope y'all got y'all sweaters for the Christmas party tomorrow. When I tell you it's going to be the best WTF, like it's gonna be the best WTF, y'all. It's gonna be some, oh my God. Best show. Christmas sweater.
What, I forget the attorney's name, but that seems to be the running theme of these, the positions today. There's no bond motions filed. Like for example, Mr. Drinker, there's no bond motion filed.
Not even, sometimes there's just language to that effect with the first, when someone enters an appearance. I don't know what's triggering it, but we're gonna need to rethink our approach and just slapping everything down that got deferred for a hearing. And I think the default is you could not have had a bond hearing even if you.
Okay, so I do see that law and crime is up, and it says that I think this is up for the other defendants. We got some swapping around that we'll be doing today. I think this is up for the other defendants. Oh, period, Shawty Red. Congratulations to your baby. So yeah.
Well, that was streamlined today.
Probably why there isn't an attorney listed on the calendar either. They're
Yeah.
getting a lot of them there.
Road Dog, when he came on, he said he gonna take them as they come in or something like that. And Miss Faye said there's a problem with the defendants downstairs. So I guess when they get it together, they'll bring Yak up, but that's where we are right now. And as far as the other defendants, it's 5 left. Are they dismissing cases and taking?
So,
What's going on? Shannon's won't be streamed. She said she posted up after. Yeah, this is Yaks, y'all. This is Yaks here. I mean,
he's one of the Powells. Is Roderick Powell's your client?
Yes,
Do you want to talk to him or?
I can speak.
We're skipping. So he can go back down Roderick Powell. And we have a lawyer for Daryl Williams. Daryl Williams is here. Okay, so we can do that.
Yes, please.
Daryl Williams and Robinson Baker are the ones that are ready to go.
Key, where did that thumbnail come from? I said, is this the right stream? Because why they got them on there like that? I said, Lauren Crime said the case over, they may as well go ahead and be missed. Because why I said the thumbnail? I said, where these YNs come from? Jan, that thumbnail is out. It's insane. I can't wait to talk
Do you
about
have one of the?
Get through. I'm gonna go talk about them on
You're
Twitter.
just a hanger on. That's what I thought. Okay. You got nothing to do these days.
Right, no, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay. I got some
Good to see
things.
you guys.
Yeah, let me know.
Okay, man.
Do some trials next year. Yeah.
Baby, this show ain't
This might have been
Hey,
after your
courtroom.
time. Did you ever go to University of South Carolina for the Trial Advocacy Center over there as a AUSA?
Yeah, a lot. That was where all our trainings were.
Right, right.
Yeah.
I went to school there, and last week, Victoria, she was a mock judge. They have the district court judges go down and help train. So I got to go back down there, and that was always on campus when I was there.
Yeah.
Towards the end of my time there, it was on campus, but I never really took note of what it was. It was just some fancy building that I knew nothing about.
Nice. Yeah,
Yeah, man.
yeah, because it's the residences are there, and there's a
Right.
cafeteria, and then all the
Right, Dominique.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called the Graduate. It was a good time. So I got to take Hollis down and show them where I went to school and
Good.
everything.
Excellent.
So,
Good family event.
Yep.
We've got
That's right, Mac.
Baker. Okay. Mr. Tevis, you ready to go?
Oh, yeah, it's
Ms.
time.
Clark? we're gonna do Mr. Robinson Baker. That's who we got.
It's time, y'all. Good morning, everyone that's joining the chat. Please like the live as you come in. I've been on some other lives, so I know it's easy to forget, but just hit the X, like the live, y'all. We're just watching X bond hearing, then we'll switch to see who may have taken pleas in the other case. Not they say plenty of here. Hey Angie, well, Shannon already has a negotiated plea, so. Good morning, Erica.
I'm just saying. Yeah, that's all. No.
Thank you, Princess.
All right, Ms. Rivers, are you ready? Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for. And that'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building that I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303 Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm. And detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done the state will rely heavily on the facts because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case, they're not letting us in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle, not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to the court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. I know your background having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bonds?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
That's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but
Yeah.
the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank
you. Ms. Clark. Oh, Ms. Clark, before you go, you will come on, I can tell you, good morning. Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
Good morning, Your Honor. Yes, Your Honor, there is an active.
I can't hear you. It's odd. You're not muted.
Warrant at this
time. Can't hear you.
Your Honor? Can you hear me? Okay. Your Honor? Can you hear me, Your Honor?
Yeah, Mr. Baker.
Other people can hear you. That's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
He is on active
Just want to type in
probation.
the chat whether there's a warrant. I'll relay that. He is not yet. He does have a warrant. Okay, thank you. That's what I needed to know. Appreciate it. Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. After a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So that
Mr.
is
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, is 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There's a young lady, Kim.
I'm gonna swap over because Paige just started, y'all. So I'm gonna swap to Paige real quick. Because they probably gonna be a second.
Objection. That's one of the reasons why it needs to be done a particular way. So I have to find out when we have everybody here, but assuming no objection, you certainly may use your laptop. And if y'all have a still photographer ever, that's welcome. Any other kind of like feed can just go through the pooled camera. All right. So we'll just wait till we get everybody before we get started. Other than that, I'm gonna rearrange my.
Do y'all think someone's taking a plea today? And I'm flipping back and forth, guys. I'm watching the other one too. And Mr. Man, she's still up there. This is crazy. This is a crazy day, y'all. Jess, he hasn't gone yet. Thank you, Erica. Thank you, friend. Teamwork make the dream work. So who's gonna take a plea, Mikhail? I figured there was going to be a plea because we're in court today, and today is the last day. Oh, okay. Thank you, Jasmine. Erica, I don't know what's going on with that wig. No, wait a minute. Paige isn't the attorney for Shannon. I mean, the judge for Shannon. I think Belinda Edwards is Shannon's judge for today. So whomever is taking a plea in front of Judge Whitaker is going to be one of the remaining defendants. So hold on, y'all. Let's go back. Because yes, y'all, we playing the switcheroo today.
Make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple months were, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered him.
So ultimately, there may well have been before, we'll call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows? There may have been some back and forth, and the police may have perceived that your client was reluctant.
Right.
It's not like he's under an obligation, but
of
he
course
was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this was someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand it, and that's a That's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly, that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a danger to the community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, U.S. Constitution. That's just not the case. Ayala is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, in which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. So I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that?
That's fair.
Okay. Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. This would just be some kind of transport order, because he'll have to be released from this hold to get to Cobb.
Right, we'll work with Cobb on that so that then there's a hold put back in place. But we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this again. Okay, very well. Ms. Clark, anything else?
No, Your Honor.
All right, thank you.
I'm sorry, but the warrant made me.
Do we have an update?
Yes, Your Honor, an update on the 100 cases for this morning. I have been able to get in contact with the other two attorneys who should be here for their clients. That's Mr. Fazoli.
Okay.
He's presently in 2B with Judge Brooks doing preliminary hearings, so he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Fazoli said he is ready for Hutchison, McCaslin, and Drinkard.
Caslin, now Drinkard, okay, great.
And
does he have a client where he's saying sort of like your client, we're not doing it today?
yes, that would be for Mighton and as well as Alvin Powell, position 5.
Okay, so Ruben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes, sir.
Defer, got it. And then you said there was a third attorney.
Yes, one more. Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams.
Okay, I put him on mute just to say, so Kathy is actually in the courtroom with Shannon. She said Max just announced that there is a plea deal in the remaining case against Shannon Stillwell Jackson. He's in Belinda Edwards' courtroom, so it's happening now. So we are going to see what happens with Shannon. I'm gonna just keep following Kathy's page. I'll just keep updating it so that I'll have an update for us while we're waiting and listening. I did not think Yax. I don't know why I thought it was just going to be Yak, but no, he's in a courtroom with other defendants. So we got to go through all of these people and see what's going on. And I'm watching the other live stream, guys. So it's a lot going on today.
Okay.
And I can also say that Kuykendall is a co-defendant in the castle, so she would be
a conflict defender.
I don't know if they got those.
Yeah, maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Daryl Williams? And did you say you also have Mr. Beatty?
Yeah.
No, just, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing pro bono.
Okay.
I filed a little bit extra for the purpose of bond.
Just for bond. Okay, got it. Thank you. What do you want to do? So we still don't have Kendrick. He's not up yet. Okay, so if we got Williams, why don't we knock that out? And then do we have, who else do we have left? So McCaslin will be able to do, we'll be able to do both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Daryl Williams out, at least make progress. Uh-oh.
Key, I have paid attention.
Number 5.
Yep.
Number 8. Number 9. Yeah, but we don't do anything until someone reaches out. We don't have to proactively do anything. And then number 3 is a conflict prevention case. So, yeah, we can do that today. If she gets brought over, I'll let her know that what the situation is. Co-defendant number 4, as Cazzoli, and Cazzoli will be here. He'll be here later.
Okay, y'all, there's too much going on today, okay? Too much going on. So we're going to take a family vote, okay? 1 in the chat if you want to stay here. We got Yak's bond hearing, right? Then put a 2 in the chat if y'all want to swap to Shannon, because there is a stream for Shannon as well. So 1, 2, 1 in the chat. We're staying here for the bond hearing. 2 in the chat. We're going to swap over to Shannon. Looks like y'all want to see some people. Okay, y'all want to go with the for sure coming home today. We're going to swap there because there is a live stream going on. So we are going to watch it, but just know it's the same thing, guys. When I say same thing, it's other people in the courtroom.
He has a.
She put these calendars out a long time ago. I filed it,
And Judge, I would, and with all due respect to Ms. Jones, I would ask to have that set on a calendar or a specific calendar so I can bring in the victim. The victim deserves to be here.
I filed it on November 20th. I sent copies of it to everybody.
Does that include Mr. Marquez?
Yes, of course it does.
You said everybody. I don't know who that includes.
Well, it includes the relevant parties, Mr. Marquez.
All right, so
And the
Mr.
case manager.
Marquez, Ms. Jones is asserting to the court that she gave you a copy of her notice.
And if she electronically filed it, I don't doubt that at all. The only thing being judged, because it's set for a plain arraignment, not necessarily a bond reduction. That's the only reason that I would ask for a particular date on that.
All right, so let's deal with plea and arraignment. And according to you, Ms. Jones, he already has a bond, correct?
He has a $10,000 bond, but the bond order reads $11,000. So yes, he does have a bond.
All right, as to indictment 24 SC 004525. We're here for plea and arraignment, Ms. Jones. What are we doing?
Waive formal arraignment under a plea of not guilty.
All right, so the court will enter a scheduling order. You will be notified of the next court date. Ms. Jones, I'm gonna come back for the bond reduction and give Mr. Marquez an opportunity to reach out to the victim. We're gonna hear it today. We're just not gonna hear it right now.
I hear it today? Okay.
Yes.
I understand. I was just clarifying, Judge. Let me say this as well. There is a non-complex case that should have already been transferred to this courtroom. I'm not sure why they're dragging their heels. That case number is 23 SC 191544.
Non-complex does what it does. Delay, delay, delay.
Well, it was already delayed when I picked up this case, and I've been in communication with them for a while, and I can't figure out why they haven't submitted that. And I'm concerned about that one because that one is a criminal damage to property in the second degree. The discovery I see in the file from the non-complex attorney suggests that it's a misdemeanor at best. And he's been in custody for quite a long time. You've been in custody since May of 2023? That's 2024.
Yes.
He's been in custody since May 29th of 2024. And then he did some time on that case last year.
On the 24 SC 004525 or on the 23 SC 191544?
He got picked up on the 24 case, Judge.
Okay.
And then he's also being held on that 23 case.
They never set a bond in the 23 case?
He has a bond, and that's been reinstated.
All right, okay.
And Judge, just so the court is aware, and there was an ex parte filed on the 23 case. So it was under judicial hold status for for a little bit.
Right, and when I got the file, I met with my client, determined that that request had been made in error. It's been withdrawn, and so it's ready to come here. I'm not really sure what they're waiting for.
All right.
But there's been a lot of dragging their heels on that case.
You can look into that while we wait for Mr. Marquez to speak to the victim.
Okay.
Or have someone in his office speak to the victim.
Thanks.
All right, position number 8, indictment 24 SC 004916, Rodney Jackson. Who's representing the state?
Judge, that's Mr. Wittenauer's case. However, for purposes of this calendar, I'll make the announcement.
All right, so this is on for plea and arraignment. Ms. Jones, what are we doing?
We're going to waive formal arraignment, enter a plea of not guilty.
All right. The court will notify the parties of the next court date.
Thank you, Judge.
The scheduling order will be put in place.
Thank you, Judge.
If nothing further, all parties are excused. So we're going to move to the final plea calendar, indictment 23 SC 186907, Marquisha Knox.
Judge, she is present today. I'll ask her some time just to go out, retrieve her.
All right.
Oh, she said final,
Let's
y'all.
go to position number 2, indictment 22 SC 185436, Jawan Gaston. I don't see Ms. Rondon, so we'll come back to that. Position number 5, indictment 24 SC 001933, Javion Outlaw.
Good morning, Your Honor. Cameron Macchio, Mr. Outlaw.
Is he present?
He,
Okay.
and Your Honor, this is on for final plea, and we have a negotiated plea. I was in the middle of completing paperwork when Your Honor came on the bench, so if I could finish.
Go ahead.
Okay, thank you, Judge.
That'll give me enough time to go call my victim on that other case.
You ready?
Your Honor, I'm sorry, I still.
Oh, okay. Not a
I'm
problem.
going to follow.
We have other cases.
Oh, this judge is beautiful. And they say she very sassy, y'all. Very sassy.
Go to position number 6, indictment 24 SC 001711, Beverly Range. Is Ms. Rondon? Okay. Let's try position number 3, indictment 22 SC 185439, Aquila Carter.
Judge, I'm going to try to get in touch with him. I expect him today.
All right, position number 4, indictment 24 SC 001756, Tashawn Hodge. All right. Mr. Marquez, are you representing the state?
I am, Your Honor.
Okay.
Those that are watching Yak, I see Adam up. Adam isn't talking about Yak, is he, y'all? I have it on mute, but I see Adam is at the podium. Is he talking about Yak? Okay, thank you. I should have known Nene was watching. Yeah. Zakiya, I wanted to do a party at 10K on YouTube, but I think what I'm gonna do is just do something for my birthday and combine it, like a good meet and greet for us. I think that's what we decided to do. Hopefully the 10K is around my birthday, so it'll all make sense, right?
Good morning, Mr. Hodge. This is indictment 24 SC 001756. Ms. Jones is present representing Mr. Hodge. Mr. Marquez is representing the state. The calendar reflects we're here for a final plea. What are we doing, Ms. Jones?
Mr. Hodge is going to maintain his not guilty plea, Judge.
All right. Any outstanding issues, Ms. Jones?
Not that I can think of right now, Your Honor.
All right. With that being said, you will be put on a trial calendar and be notified accordingly. If there's nothing further, all parties are excused.
Yeah.
All right, let me go back to that.
Judge, can I have 2 minutes to?
Sure.
If I can. Thank you, Judge.
Is Attorney Lewis present in the courtroom?
I'm sorry, Your Honor.
Lewis?
Yes.
Okay. Before you arrived, the state announced that on indictment 22 SC 182298, Janice Dillard, that they are going to null process that case.
Judge, of course you know I have no objection. And it is good to see you. I saw the meeting here and I said, oh, they think you on the bench too. And you told me it was for something else, so.
Of course.
Judge, is it possible to have this matter sealed without a formal motion, or do I need to send that? I can do that.
As long as the state isn't objecting, so you can get with the state.
Okay.
Mr. Marquez just stepped out, but you can send him an email or follow up.
Yes, ma'am.
I don't think it'll be a problem since they're not proceeding.
Yes, ma'am. Sounds good. Thank you, Judge.
All right, if there's nothing.
Concluded, my time now be excused.
I was just about to say, unless there's something further, all parties are excused.
Thank you, ma'am.
All right,
Have a great day.
you too.
Yeah, y'all know I haven't streamed for a while. Y'all got the likes at 300? It's 700 people in here. Can y'all please do me a favor? Click the X and like the live, please. I don't know how long I'm going to be streaming today because we got a couple of things to talk about, but please like the live. Please, don't do your girl like that. It's been a minute since I streamed, probably over a week. Like the live, please. It's unpopular. But as long as you really like it, then it's okay.
Deputy Hudson, let me know when something's ready.
Baby, Linda just got up. Baby, I know that's right, Casey. Y'all know Jackson State Celebration Bowl. They are the HBCU national champions. Casey was asking, did I go to the game? I didn't have anyone to go with. Mariah did not go with me. She doesn't like football, so I had to watch it on. A little sad about that. I was a little sad about that, but they won. Okay, there's no one in Judge McBurney's courtroom. I'm gonna swap for a second. Nobody is in McBurney's courtroom. So let's swap over there. But yes, it was yes, y'all, we are the reigning champs, okay? Okay, congratulations to Jackson State, the Jackson State University.
Because the day of telling my kidney, okay, she said that new thing show that my kidney was good, but I've been at a plant, a transplant, okay. All right, my brother gave me a kidney. And they just don't do that for people, you know what I mean? They just don't do that for people like that.
Okay, well, that's what I'm gonna talk to them about. And are you on dialysis, or because you have a new kidney, you're not on dialysis?
See, I go back I had to go back for every 3 months.
Okay.
To be put on, they call it, extra dollars, okay? Like, you know, I don't build it like, people out like that, build like overnight.
Okay.
Out loud, you know.
Well, I'll talk with the doctor and
This is too much now. This is a lot today.
Mr. McMullen, but we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the attorney, via any of the defendants?
Yes, Your Honor.
All right, why don't y'all come on up to the podium, please?
I know Demiki don't want to plea, baby. Don't take that to track.
I was shocked when I found out that one prenatal vitamin a day is not enough to give you the nutrients needed.
Y'all know I'm on line crime. My bad.
And everybody, I'm just gonna give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183-572, State of Georgia versus Mr. Miles.
I'm gonna come back to Miles because my nerves can't even take Miles right now. I can't believe Miles about to take a plea. We're gonna go to Yak's hearing. Oh Lord, that just made my nerves bad. I'ma pause Miles, guys. My nerves bad. Come on, Kayla, do your thing, baby.
All right. Ms. Rivers, are you ready?
Yes.
Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick. I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity, given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom
No, he
or?
was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge. And in that case, it's my understanding that the judge decided that there was, the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions granted, given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the two cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Great. Yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on two separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Kendrick.
Honor.
All right, somehow that device's volume got turned down, but we're back. All right, so your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault, I'm gonna call it the assault case.
That's correct. And in addition to that, the sheriff's office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, what else am I gonna do? It's about respect. They're stealing my stuff. I gotta do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend. and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Yeah, this is crazy.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the two cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we will be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations. Or it would be something in aggravation at a bond hearing or at a sentencing hearing. That is your best forecast with maybe one exception.
That's correct.
Okay. All right.
Thank you, Judge.
Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed or if it's lifted or it's dismissed or I know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter or is this our universe? The assault case and the contraband case.
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case are one occurrence.
I got it.
And that the additional alleged acts in the jail I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's gonna do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or
I will keep everyone in the loop.
Okay, thank you,
Okay.
Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you for being here.
Kayla said, send me to the other courtroom, please. Send me to the other courtroom, please, guys. And for people, y'all know what really bothers me is the comments. Oh, she sucks. Baby, she did a damn good job. And first of all, she can't control what seems like retaliation from the state. I'm sorry. After holding his life for all these years, they could very easily just let this man go. They very easily could have worked out a plea deal, anything. It didn't have to necessarily be bond. And I'm hoping they work out the warrant because Too Pretty, I was going to type to you that it's not child support. He has, y'all sit on my glasses, so if they crooked, I'm sorry. It's not child support. He actually has to, they're saying that he thought he only had 1 probation, but it looks like there were actually 2 probations, state and federal. Lord, y'all, this bothered me, state and federal. So he has to handle that before he's able to go. So I'm going to go ahead and share Shannon's. And then, so there's Miles Farley took a plea. I think Erica said it was a Alford plea. So we will see. Oh, did it come right in time?
We're back on the final plea calendar with indictment number 1, 22 SC 181814, Shannon Jackson. His attorney is present, and the state is represented as well. We also have indictment 22 SC 185532 and indictment 23 SC 188183.
Your Honor, before we get started, may I approach with something off the record?
State has to approach as well.
The judge said, "Don't come here with that beat." I was coming in with the courtroom. It's all Taylor should be pulling in the courtroom right next to each other. It's definitely right next to each other. Let me tell you something, Judge. That she not the one for the okay? Listen, she not the one or the two. I hate Yak get that warrant. Oh, I hate he get that warrant because I think he would have came home today if he didn't have it. I really. She blew her breath out. She did, baby. She said, "Don't come in here with that mess down pulling in courtroom on the seat." Taylor right next door to me. The courtrooms are right by each other. So days of our lives. I don't know that she knew that, especially since when you're talking to your client, you feel like he has that. So yes, charges are stemming from. Okay, I don't like talking on that. Yes, charges someone was stealing his stuff, and he literally hit and beat the person with the extension cord, allegedly. Okay. So I'ma just give him props for not doing something else. So I'ma just give him props for not doing something else. Yeah, Kayla, I had to turn it off because I could barely hear myself. Yes, Key literally did that. He that's very much true. He did, y'all. That's the allegation. That's the allegation. And I'm sorry, he could have done it a whole lot of other ways. I'm not condoning any violence, but I am condoning the fact that not condoning it. I guess I can appreciate he didn't try to kill the person. So yeah. So WIAC is going to have to go back. They have to figure out that warrant situation. So I'm gonna say it'll probably be handled within the next week. It sounds like the judge was telling him, yeah, this is Shannon's hearing. It sounds like the judge was telling them that this is something they can work out without doing another hearing. So if they can figure out the warrant, maybe they can email back and forth, figure out where Yak is going to be staying if he were to be granted bond. After that, go from there. Erica, he allegedly beat someone with an extension cord. Allegedly. So that's what he was saying. So it does sound like Kayla's going to be able to handle this offline, an email to the state, trying to see what's going on, and then go from there. Is that Love? Where Miss Love at? Y'all see Miss Love? I didn't see Miss Love. Y'all keep saying that. I haven't seen her. I hadn't seen her. But yeah. Y'all, the courtrooms are right next door to each other. So she didn't have to get on the elevator. They're right next door to each other. Yeah, Tati, it sounds like Yak's housing is in order. It seems like all the housing for Yak is in order. I think they want to make sure they provide it to the judge, like off the record, so that everyone will know his address and all of this stuff. It sounds like they're saying that he is going to be taking some time for himself. So he'll be recording in whatever home he's released to. So So yeah, so there's that as well. But I guess, you know, the win that I see out of court today is there is hope. It sounds like the judge has hope. Yeah, I think it sounds like it's very likely that he's going to get out. So here's the thing, that it's not about he can't. They said co-defendants, all of his co-defendants are in jail. Because remember, he was acquitted of all charges. So he can be around Shannon, Thug, DK, Duke, whomever he wants to be around. He was acquitted of all charges in that YSL RICO case. So those are no longer his co-defendants. His co-defendants are going to be the people that are in jail. But I think what the judge is just trying to say is, even though you were acquitted, let's make sure that you're going to be successful once you get home. We don't want you to have any probation violations or anything like that. I'm assuming that's what he's going to say. We'll see what his conditions are for bond, if, you know, once he gets it. But yeah, he was acquitted of the YSL RICO case. So he shouldn't have any problems or anything attached to that case. His issues are going to be yes, King. It's going to be this case. Hold on just a second. Yeah, so that's it. It's going to be this case. The one that he caught while he was in jail. Those are the co-defendants that McBurney was talking about. But I know a piece of me, if I know this man and how they like to do people that look like us, I'm sorry to say it, I know there's a piece of him that is still in the back of his mind thinking about that YSL case. Which isn't fair, because as so many of you guys pointed out, he was acquitted of those charges. So his bond restrictions, okay, yeah, they back.
We're back on the record. Bring the defendant, Mr. Jackson, out, please. Good morning, Mr. Jackson.
Good morning.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor.
Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty acknowledgement waiver of rights.
Yes, sir. I remember.
And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Shard, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Shard? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand this is a negotiated plea of guilty?
Yes,
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you were under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon?
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. Do you understand you entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2?
Yes, sir.
Do you understand that you'd also be entering a plea under Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by intent?
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm a lawyer. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file that habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle, Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 is going to be 10 to serve 3 commuted to time served, balance on probation, as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1.
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, so statute minimum of 1.
Okay.
So if we're going to get there, man,
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3 commuted to time served, balance on probation. Count 2, 5 years probation consecutive to count 3.
Yes, sir.
Yes, sir.
And count 1, 3 years to serve commuted to time served.
Correct, sir.
Yes, sir.
You may continue.
And as to case number 23 SC 188183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judges, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication directly or indirectly with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer, correct?
That's correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. However, I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that would probably be the best workaround at this time. And quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with Probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seat. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay. All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Indictment 22 SC 181814, count 3, 10 to serve 3, commuted to time served. Count 2, 5 years probation, concurrent to count 3. Count 1, 3 years to serve, commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation, to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years, and nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are to not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there. So there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you and Ms. Brother's partner, I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So at this time, is there anything else from either party?
Judge, just Mr. Chardon recommended, I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Chardon and I have built up a point of trust and communication over the years. I have no problem with Mr. Chardon reaching out to me if there's any exceptions that are necessary. That's good.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
All right, Shannon coming home today. I know that's right, Shannon.
Business after probation.
Great job, man.
Yes. All right.
Position 7 on the final plea calendar.
Hold on.
Excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
I know that's right, Shannon. Shannon said he going home.
Sorry, Judge, Ms. Knox needed to feed the meter.
I know that's right. So at least, so Shannon is gone home today. I really feel in my heart of hearts that Yak will be home by Christmas. I don't know. The judge made me feel like he is very much open to this after this warrant is resolved that Yak has with probation. It seems like he's very much open to letting Yak receive a bond. So I do know that y'all know, hold up, y'all know I gotta text her and tell her congratulations. And I gotta tell my girl congratulations, okay? Because I know she is like, let me just say too, for people in the chat, they were like, oh, she's nervous, she's nervous. She was very nervous walking into Yak's bond hearing, because she does it all the time, right? But there was so much added pressure because people know she does bond hearings and she gives people bonds all the time. She was very nervous walking into it. And I'm sorry. I feel like if it weren't for that warrant, Yak would have been home. If it wasn't for that warrant, Yak would have been home. But she really was nervous walking into this because there's so much pressure. Everybody is like, Kayla gonna get it done. Kayla's gonna get it done. And I think, like I said, had it not been for that warrant, I still feel like I still, in my heart of hearts, I think once they once they figure out that warrant, Yak is gonna be home. So I'm telling y'all, my glass is really killing me. I slept on them. But I really, in my heart of hearts, I know Yak come home. You know, I think she did a great job. Like pinpointing, first of all, what bothered me most about Yak's hearing was the state. Like, y'all have already taken almost 3 years of his life away. And the fact that he's like, oh, he was seen fleeing from the home on May 9th. He was acquitted of all those charges. He was acquitted of all those charges. So why are you trying to use that to keep him in jail? Like, that bothered me so bad. And for him to say he's a repeat offender, he hadn't been in trouble since 2015. It was very much misleading, very much giving Miss Love. Very much giving Miss Love, oh, he's a repeat offender. It was the same charge. Like, when Kayla pointed out that the state charge turned fed, it was like, okay, sir. Very much misleading. Like I said, very much giving Miss Love. So that was very telling. And the fact that he ran through all 13 of those infractions that Yak's gotten, and y'all don't even want to go forward with those. So why are we talking about those? Very much giving Viverito. Come on, Lynn. Why are we even talking about charges that you guys don't even intend to bring to the court? And that's what the judge was saying. Okay, so y'all talking about those. Are y'all going to come forward with those? Because, as he pointed out, Yak and his attorney have a right to know what is going to be brought forth so that they can prepare their case. So Days of Our Lives, I'm not sure, because I've seen you in here this whole time. It feels like you're seeing what you want to see. Yak was going for a bond hearing. Max went for a negotiated plea, which Kayla helped do as well. So, all of this hate towards Kayla, if you're not an attorney, let's just stop it. Let's just stop it. Go look at her success rate with getting people out on bond. So for you to say, oh, Kayla should have been as prepared as Max, were you watching where we watch? We all saw that a warrant popped up. Like, we all saw that a warrant popped up. So as far as being prepared, that judge, I'm sorry, y'all. I really think that judge was letting Yak out if it weren't for that warrant. I really do think that, y'all. If it weren't for that warrant, I think so. So, I hate that Yak has to sit there for a little more time. I hate that he has to sit there for a little more time, but I know he's coming home. I really do. She said you saw the warrant pop up. I'm on live with you, friend. How I see anything pop up? Come on live with you. When I'm saying pop up, I'm speaking to you guys. So I'm not speaking in I'm probably not using the word that you want me to use, but I think you get my drift. So my whole point in saying this, and you can have y'all be trying to let people have a different perspective, and that's fine. But what I don't like is for people to try to like bash people just because you feel like that's cool to do, or you don't like a person. I don't like that. So I'll be trying my best, like, hey, come over here, let's talk. And look at, not Crystal. Come on, Miss Sheila. It's not about giving your side, Days of Our Lives. It's about you. I don't know. We like to keep it. You can have an opinion, but it kind of seems like you just are in the mood to attack Kayla. So it's not about not giving your side. You can give your side. We welcome opposing opinions. We welcome that here. But what we don't appreciate, and I think what the chat is saying, is for you to try to attack her. I mean, I've seen some of your comments and it just seems like you don't care for Kayla, and that's fine. But what we don't want to do is diminish the work that she does do. She is an actual attorney. She actually does do work. She's actually good at her job. I don't want my life to be a place where someone feels that it's okay to attack someone. And it kind of sounds like where you're going. It's not a difference of opinion. That's fine. But Kayla should have been as prepared as Max when they're two totally different hearings. We had a bond hearing, and then we had this. I didn't see your comments. I didn't see any comments about this when the other young man was up here, and they said, "Oh wait, you've got a warrant." I didn't see the comments like, "Oh my God, his attorney wasn't prepared." That's all I'm saying. I didn't see the comments for that attorney when that came. So no, McKay, I think he just made another page, but he's been chill. So yeah, back to that. So hate that I know that's right, Keith. You're right. Let's get off of it, but I had to say that because I kept seeing it. I kept seeing it. I was like, oh my God. So yeah. I was like, wait a minute, purple alchemist. But yes, guys, so bring the South Memphis out. No. So anyway, y'all, I think that concludes it. I'm kind of sad about Miles Farley because Miles he took an Alford plea though, and let me read you guys what Miles took today. A little sad about Miles Farley, but again, I always go back to something Kayla told me when we talked about taking pleas, and this was before anyone took pleas in the YSL RICO case. Okay, Lynn, Kayla said that male juries are unpredictable, and she said, you know, when you take pleas, at least you know what's about to happen. So yes, Megan, we're about to watch that now. She said, at least you know what's about to happen. And at first I'm like, girl, what? But after sitting through Thug's blind plea, Shannon and Yak's plea, I am going to have to agree because it was during Thug's blind plea I understood what Kayla was saying. So, you know, when it comes to Miles, you have to do what's best for you. And if this was the best thing for Miles, okay. Miles he took a plea in the YSL RICO. He has an Alford plea. He has 5 years on probation, no jail time, and he pled guilty to count 1 RICO. The murder charge was dropped. Happy about that. And now we only have 4 defendants left from the original 28. So y'all. So we're gonna look at Miles Farley's plea that he took today. And let's see what Mr. Miles had going on.
Everybody, maybe position
Yes, Brianna, then there's that.
Ms. Private, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? And how far have you gone in school? I got a bachelor's degree. And are you able to
also speak into the mic, please?
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either guilty or not guilty to these charges. And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years? Yes. And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to? No. And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Yes. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts? Yes. And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir? Yes. Do you also understand that by pleading guilty, you're giving up or waiving the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572? Guilty on the Alford. And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. And do you understand that you may have a limited right to appeal this guilty plea conviction? Yes. Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Manatas, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just for the record, it's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to
All right.
the defendant's guilty plea to count one, conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation will be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon, understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Manatas, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area, his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor. putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again. And he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alford is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
I didn't have any special conditions, obviously, I've been following the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you are following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Miss Jolly is on.
She's a little condescending like that. That pisses me off. She said, make sure your business is on the up and up. It's a clothing brand. That's the stuff that just pisses me off sometimes, that God's still working on me. Girl, the man just explained to you his business. I could see, I don't, can y'all find Miles' Instagram for me? I've been trying to find his Instagram, his TikTok or something. I'm trying to reach out to him. Hey, Ronnie. Like, she was a little petty for that. It just rubbed me the wrong way. So I did find Max, and I wasn't being messy. What I was saying was, I did see on Twitter the back and forth with Mr. Dennis and the Cuff Boys guy. And he did a reaction and then he copyrighted his video. I don't want those problems, okay? Because if truth be told, y'all, I've been doing YouTube now for about 2 or 3 months. Tell me why I was on the phone the other day with Miss Jefferson and Kayla, and they're like, how much money did you make off YouTube? I'm like, I'm not really making money. In fact, I think the only money I've made are my super chats, right? For people who do YouTube, make sure that after you do a video, you go turn the money sign, you go turn the money on your videos, okay? So while I have friends that have made $3,000 a month off YouTube. Man, one of my friends just said she made $6,000 last month, and I'm sitting here like, why am I not making money? Go turn your money sign on your videos after you post them if you're doing StreamYards, because I literally did not do that. Oh my God. I did not do that, y'all. And what's so crazy is I was seeing the money sign green on some videos and not green on others. But like literally, and this is why, my life has kind of been all over the place. We'll talk about that one day. And I could not think, which is why y'all haven't seen me online. I've been taking time to actually gather my thoughts and think. I haven't really, outside of probably Twitter from watching something, I've been trying to gather my thoughts, y'all. So when I tell y'all I wanted to cry, I wanted to cry because why didn't I like just, y'all, you can't, this is why I'm going to tell y'all again, when you stay ready, you ain't got to get ready. Because not me been doing YouTube for 3 months. And I'm like, why am I not making money for real on YouTube, right? Like, KK, I'm sorry, KK. I'm not a big fan in paying for courses when I can sit down and do the work. Like, I'm just not a big fan of that, especially depending on the amount of the course. I've seen that he has a course. And if I get to a point where I really need to, I'm taking these 2 weeks to kind of learn YouTube. I've already started reading and stuff. But anybody that knows me, and it's not elite, anyone who knows me will tell you I'm a researcher and I'm going to need to see it myself. Yes, Key. Yes, y'all. So, yeah, I have been taking the time, like, I had to withdraw from school, just taking the time to kind of clear my mind and try to figure out this stuff. So when I do figure it out, I can share it with y'all, okay? Because no, too pretty, baby. Let me tell you something. The tears was forming. They were really, really forming, okay? Because when one of my homegirls said, oh, I made this much off YouTube, I said, you made what? Then my other friend said, I made this. And then one of my other friends said, I said, how's y'all? I'm like, I'm getting the views. I'm seeing my videos. Like, I'm seeing my video. I'm seeing the views. Y'all, when I tell y'all, when I went back and the fact that I'm like 80 something videos in, and the fact that of the 80, maybe only 4 or 5 had the money sign turned on. Yeah. Roll dog. No, Brianna. So I got all my super chats, guys. I'm working on them so that I can, because they say they send me a pin. I haven't found the pin, so I'm working on that. So I turned it on the other day, y'all. I turned it on the other day, and I'm telling everybody on here that needs to do YouTube, that wants to do YouTube, make sure once you're monetized, you making sure your videos have the signs on. Like, I'm talking, y'all, I had some videos that did pretty well. Yeah, oh yes. Thank you, Miss Fab. Yeah, I'm doing Miss Fab just brought up something else, so I'm getting ready to do Twitch. I'm excited about doing Twitch. Uh King, don't do me like that. I'm getting ready to do Twitch. Hey, India. So India, let me tell you something that's a personal thing with me. I have been in other YouTubers' lives. I personally hate when it's a live and ads are going on throughout the live. I hate that. So I turn them on. I prefer the ads after. So if people catch the replay, I really hate it. I know I need to do better with that, but I just think it ruins the experience. I think it ruins the experience. I don't have ads. Ads should be on because I gone back to watch my lives and I've seen ads. So ads should be on when you go back. I saw they just did an emergency something for TikTok. So we'll see what happens with that. But I don't mind the ads. Yeah, I don't mind the ads after the live is over. I think it ruins the experience when you are doing ads when you're in the live. Me too, Isis. I've seen them on the replays. So Kaylin, I hope that's great. I'm going to be I started my Twitch yesterday. So thank you, Graceful Virgo. I started my Twitch yesterday. I am getting my content calendars together so that I can I'm like super excited about Twitch because I want to I'm subbing to some Twitch accounts so I can kind of see how they do it. But I have a pretty good idea of how I'm going to run the Twitch account. You never seen the ad on replay, Key? Oh Lord. Okay. Kaylin, they want to know, do you link the Twitch to your Amazon Prime? But yes, I started my Twitch yesterday. I'm reading up on Twitch now. By January 1, I should have Twitch set up. My YouTube should be better, content more planned out, some live interviews. So I'm working on those things, guys. So that's another reason why I really haven't been streaming. I might be watching something and working on my laptop because I'm just excited. I actually like doing the streaming. So for people that yes, I went back and put the money sign on, guys, but again, y'all, this is why you gotta know, be ready, right? Oh, thank you, Keith. Thank you. I love y'all. But I think for people that are interested in streaming or content creation, there is so much that you have to learn. And for me, I really wish all the years when I was planning content, I want to do this. I wish I took the time then to be doing all this research because I'm doing it now as I'm going. Me and Miss Jefferson and I, we were cracking up with each other the other day. We was like, babe, we kind of going with the flow, figuring it out as we go. Ouch. So I just want y'all to do that. Make sure if you are doing content creation, it can be overwhelming because there's so many things that you need to do. And I have to stop myself with this mindset of, I don't want to charge for this. I don't want to do that. I appreciate this, but I really do want to do this full time. Y'all know Black Oprah in the making, okay? So Brown Sweet Girl, I ain't seen it yet. So I'm gonna have to request a new one because my money just sitting there. The money that I have made is just sitting there. But yes, it can be overwhelmed because there's so many different ways and you want to do it the right way, because even though this is your job and you want to make money, for me, there are people on my lives that we've been through this. I always say my crew that was sitting on live when I couldn't even bring people up. So my YouTube is still going to be here. We're getting my memberships finalized, but then I have Twitch where I want to do special streams when I have guests, or we're talking about different topics, or am I going to use trying to navigate what you're using all of these different sites for is key, right? Yes, blackmail. Come on. It is key. So Tay, you didn't hear me say Black Oprah, Tay. So it's a lot of navigation. Yes, Blake. Yes, Blake. Hey, Haken. So, Day, I'm still gonna have my YouTube. You don't have to do every platform, right? So you don't have to do every platform. You don't have to do that. So navigating how to maximize your opportunities on different platforms is where you really got to sit down and think about it. It's really not just getting on these apps and going live. You really need to make sure that you're giving, Brianna, I know what you was talking about. You need to make sure that you're providing like good content. And like there's so much that I'm like really excited to do, like podcast is coming. There's a lot of stuff because if y'all had noticed, I do talk a lot and I like talking. And I like that people like hearing me talk. But if I'm going to take this serious, then I have to put my business hat on and start looking at things a different way too. So, oh, Tara's watching the replay. So yeah, so I'm excited about that. But I did want to make sure I told y'all that if you're doing YouTube videos and you are monetized, please make sure your money sign turned on. Please don't be y'all. I started YouTube before I left for Memphis. So I probably started my YouTube. Oh, I remember when I started my YouTube in like September, October, November, December. So yeah, it's been about 90 days. But the important thing is that we got it now. Yes, Tay, I sure can. I actually because I didn't do accountability Sundays for the last 2 Sundays, but we've always talked about getting into talking about content creation. So on one of the accountability Sundays, we can actually run through what you do on these platforms, what you use them for. I can create something for us to go over. That's really simple because as Miss Fab said, we got a whole chat. Like we can work all of this together. Shannon, you know I don't live in Memphis. I'm actually, well, let me stop. I'm going to Memphis. What's today? I may be going to Memphis. I'm going to Memphis this week. I had a death in my family. So I'm going to Memphis this week for a funeral, but I'll be back. After the funeral. The funeral is on Saturday. So I'll probably be back in Georgia on Sunday, I believe. So yeah. Kiana and Key, not y'all start off in the trenches. Yeah, Key. Key, thank you guys. Oh God. Oh my God, Key, don't be messy. Yeah, it's so crazy. My mom, one of her closest cousins passed, and they were like, she's one of the cousins. My mom like, oh, call her, let her pray. Thank you guys. So Leah, keep being messy. Key's been messy. So it's one of my cousins and one of my close cousins, like, not just a distant cousin grew up with, all of that. So we have to so yeah, we're going home for her services. And Key said don't go live while I'm in Memphis. So I guess I won't be live while I'm in Memphis. I don't know, y'all, because I just thought about something. I think I'm gonna be in Memphis for longer because I have the funeral and then Christmas is coming up, and I think we were all going to Memphis for Christmas. So I think I'm gonna be no, Didi, it's not I forgot, friend. I just been doing a whole lot, friend. Not only a whole lot. I think hold on. Like a sis, not a cuz. Oh yeah. So I think it's just Didi, like I'm telling y'all, one day y'all have to give me some time to sort through my feelings. I would definitely talk more because I like to be transparent with you guys about everything that's been going on or whatever. So I hope it's there. I hope it's there, Eric. It should be there. So it's just been a lot going on. So I haven't been on as much, definitely haven't been streaming as much. One, I need to like gather my thoughts, gather myself. And I'm gonna tell y'all, when I tell y'all my sleep pattern's so off because I haven't been getting up for court. Like, it's been so off. It's been so off since I haven't been getting up to go to court. It's been terrible. She better just do a little X post or something. Didi, did you message me again? Didi? Can you message me on Instagram? Because I didn't see if you messaged me again, Didi. Because it should come to my primary inbox. Y'all, when I tell y'all this morning, I woke up at 8:58 and I set my alarm, but again, I was up late braiding hair. Yeah. Mikhail, I don't know. We're gonna leave him. We're gonna leave him where he at, Mikhail, okay? We already got to deal with you. So, Mikhail, someone on my Twitter yesterday said, Mel, you have a gift for going live. And they were like, I was on your live and it was a guy and his mama. I said, oh, that's Mikhail and Mama Jenkins. I said, oh, we like a little family. So we were probably just talking today, nothing in particular, and you saw them. So yes, Kayla, let's do that. They said, wait, who's EP? Oh, thank you, Tasha. Key, I really believe, I don't know if I've told you guys that I think it's like a trauma response that my phone is always on silent since my mom passed. I'm working through it, guys, okay? But my phone is probably always on silent, and I think, I don't know, it must have still been on silent this morning. I'm working through that, guys, okay? But yeah, somebody just say, let's get to Max real quick before I forget. I've been telling her to go live more. Mikhail, I love your mom. Love your mom. But yes, yeah. So there, I have a couple of things that I'm really excited to do.
I think for the time being, it's my belief that is what's best. Sometimes a change of scenery is important, and we're hopeful that a change of scenery and the continued support of so many people will lead to a happy ending to this story.
Do you know what stage he plans to live in?
I'm not going to share that information.
Did the Alfred plea play a factor into accepting the plea in the negotiations? If that wasn't on the table, would you have been amenable to another plea where he still would have been free, but not?
Well, the no contest to the gang act charges was important to us. We just sat through a trial for the last couple of years where we've been bemoaning the fact that people have pled guilty to gang act charges when there was no indication that whatever was done was in furtherance of any gang. So I didn't want to turn around and do the same thing. So it was important that was accepted as a no contest plea. Certainly in a situation like this, and I thought ADA Sperry said it well in court, time was of the essence. There was really no reason for Shannon to continue to sit at 901 Rice Street to wait for the lawyers to figure it out. So we were appreciative of the state for agreeing to that resolution and that no contest plea.
We had to talk between courtrooms, obviously, to get there. Yes.
Right.
Ms. Bumpus, can you talk about the conclusion, well, not really the conclusion, but what the judge decided or not decided for your part?
Well, as you know, Judge McBurney made a decision to defer in making a decision based off of a potential probation warrant. I don't think the state knew about it or the judge knew about it, and I definitely did not know about it. So it was something that was a surprise to all of us and something that is still being confirmed.
Oh, so you didn't know going in that it was a warrant, because you were obviously prepared for that.
Judge McBurney said from the bench that he was told from probation about the warrant. The state did not know about the warrant. Well, it's my understanding they did not, and the judge did not know about the warrant either.
So what is that? Like, what do you think of that? Just got to sort that out.
Quickly going back to Mr. Jackson, how long has he been in jail now? Is it since the beginning of 2021? 2022?
Since March 17th of 2022, he's been in jail
And
continuously.
what's the total, I guess the amount of probation is?
So from the case that we just tried, we did not challenge the possession of a firearm from March 17th. So the jury found guilt on that one count. He was sentenced to 10 years to serve 3, commuted to the time he served. So he had 7 years of probation going into today already. The sentence is 15 to serve 3, commuted to time served, balance probated concurrent with that. So essentially today he's gone from 7 years of probation to 12 years of probation.
So given all the cases, basically, it's 12 years of probation that
Yes.
he's now dealing with.
Correct.
No, it's concurrent. Concurrent. 12 total.
On the other plea they took with Judge Whitaker.
He has 7 years probation, and now this is 12 years, but it's running concurrent. Yeah.
I know there's attorney-client privilege, but in general, are you able to just share? You were pretty reflective in there, talking about how he's grown up, he's learned a lot, he has 4 kids. Either way, you can talk about just kind of what his mindset is as this chapter.
The thing about Shannon that I love about Shannon is he cares deeply about people, and I think that this whole process, and probably certainly at the age he is now, where he's more reflective, he's realized how much certain people mean to him in his life, and it's just a matter of we talk often, and I'm not going to share too much, but we talk about life, and I think he's beginning to realize what's really important in life, and I've encouraged all those people also to make sure they continue to be there for him, and he just sometimes I think we get so used to trying to survive on our own, and we forget that there's people there to support us, and sometimes we need to lean on those people, and that's what I'm hoping he will do, because I know there are many good people that are going to be there for him.
What do you expect him to obviously touch the grass?
So we've already been in contact with the sheriff department. The paperwork needs to go to the clerk of court. Then the clerk of court needs to fax it to 901 Rice Street, and they need to look it over. But I'm anticipating he would be released later on today. And if he's not, then when I wake up tomorrow, that's going to be first on my agenda, is to figure out what's going on.
Is anyone from his family wanting to talk or share their thoughts on his release now?
I don't think so. I think everyone's just appreciative, and but I don't think anyone wants to go public to make any statements at this time.
Mr. Kokomo, how are you feel today? Oh, very good.
No, I just hope that we can keep fighting and pressing for Mr. Kendrick so we can get him out sooner than later.
And Ms. Pompous, are you also one of Mr. Jackson's attorneys?
I'm a halfway co-counsel.
She is.
Okay.
She's
I
being
just
modest.
wanted to make sure I wasn't, yeah.
She is co-counsel. Yes.
Does
Good.
he prefer, I'm not haven't covering the whole thing. Does he prefer Mr. Jackson or Mr. Stillwell, or what should we?
So he prefers Jackson.
Okay.
He was listed as Stillwell in the indictment.
Right.
For the trial, and I just got so used to referring to him as Mr. Stillwell because I just thought it would be easier for the jurors to keep track of one name, but he does prefer Mr. Jackson.
Is it, because I guess we've referred to him as Mr. Stillwell in the other case.
Right.
Would we say Mr. Jackson
Yeah, that would be fun.
I like that. So, did he tell you when the first meal was gonna, when you'd like the first meal to be? You know, I heard rumors of menu floating around, you know, do you want to know what his first meal is gonna be?
I told him I got him at Five Guys.
Oh,
I'm simple, man. So,
not a budget meal. Come on, get that man some.
nah, he'll be all right.
Child, now he asks, do you know what his first meal is going to be? I just want Kayla to film y'all, I really think all of that food that Kayla put in that tweet, I'm sorry, but I think he's going to come home to all of that, which is hilarious. Let me find it, y'all, so that I can say, for those of you that didn't see the tweet. So Shannon requested, he requested food, okay? And he didn't just request like any food. He has like a list of food, okay? And not the list of food, let me find it. Hold up. The list of food is insane. Hold on, y'all. I gotta find it. I thought she was joking. I really thought it was a joke. And it's not a joke. It's like for real. Okay, let's read it. Mac and cheese, collards, turkey chops from Southern Fried Chicken. Okay. Ruth Chris, he wants some stuffed chicken from there. Baby back ribs from Houston's. And it's like it's from so many different places, which is hilarious. Then he wants some honey ranch and lemon pepper wings. I've never tried those, but I might eat them today. Honey ranch, because I already like me some hot lemon pepper from American Deli. But honey ranch and lemon pepper wings, okay? Then he wants a thin crust beef pizza from Pizza Hut, okay? Then he wants to go to Spondivity's. He wants a seafood bag with shrimp, corn, sausage, and eggs. And to drink, he wants a Dr. Pepper. Okay? And I would have liked him to say, this is what I want my first week out. But no. He said first day out. Okay? This looks like more like a first week out type deal. Every day we go somewhere different, you know. No. Mr. Stillwell Jackson. Okay? Mr. Stillwell Jackson wants all of this food on the first day. He's gonna need something. Somebody said Shannon's gonna eat all that food and he's gonna spend his whole first day out on the toilet. Like, this is a lot of different things. So I'm really interested. Erica, apparently Shannon can. I'm really interested. Wait a minute, cheesecake, no toppings. Aisha, I missed that one. Hold up. I missed that one. So it's gonna be really interesting. And I actually hope they record it. Like, I don't know what their plans are when they leave today, because he's coming home. I think he'll be out today. But please record it. Because I know this man is not about to eat all of this food. I know he is not about to eat all this food. I don't know if he gonna eat or sleep first. Probably eat. They're gonna be eating leftovers all week, which is why it should have been like an all week thing, you know? But no, Mr. Shannon Stillwell Jackson says he wants this food first day out. Y'all think Tasha, Kayla's gonna make it to WTF Wednesdays, baby? Kayla is going to make it. Right, Mikhail. She should. We'll see, but she should do that. You said Grandma Betty's getting out right now. He may get out late like Thug. Thug really didn't get out late. Thug was out of jail 1 to 2 hours after he left court. Remember, the court hearing was late that day. Ma'am, but Key, she is going to make it. Like, y'all, tomorrow. Listen, we have a really big show planned for you guys. Excuse me. We have a really big show planned for you guys, okay? And let me just say, Kayla orchestrated this really big show tomorrow. So there is absolutely no way Miss Ma'am put in all of this work to not come to the show. There's no way we should. I love Grandma Betty. There's no way that and when I say a really big show tomorrow, it's going to be the biggest WTF Wednesday we have ever had. I'm hoping, I just know for sure the numbers on WTF Wednesdays better be better than, like, I don't know if y'all was on Miss Jefferson Live yesterday. She said every Tuesday. Hold on, y'all. Hold up, y'all. Miss Jefferson said every Tuesday something would happen. And she is not lying, y'all. No hints, guys. But every Tuesday, something would freaking happen. And with me, Miss J, Kayla, y'all, we be on the phone like, oh my God. Like, why would it happen every Tuesday? Every Tuesday. Hold on just a second. Every Tuesday. Hold on, y'all. Okay. Every Tuesday, y'all. Every Tuesday, it seemed like something would pop off, or even like the weekend that would have us so nervous because, like I told y'all, like I love the vibe of WTF Wednesdays, right? But I would also get like upset when the focus would be off of what we were on there to do. Like Tuesday, it pop off. Kayla's supposed to be married to Shannon. And I'm sitting here like, what the? Like, where did this come from? I'm seeing a marriage license. Kayla's not saying nothing. So I'm literally fighting for my life in all of my lives outside of WTF. I'm getting drugged through the mud on TikTok. I mean, it's like, then WTF, we get on there. Stuff has happened in court, but nobody wants to talk about that. So we literally had to, like, because Key, listen, no Trendy Tuesdays, Mikhail. It's literally that. Then Abate, not Abate. Y'all remember we had to do a special live because Viverito walked up on Kayla in court. Like, it was literally, y'all, it was always something. Okay. Please let it be guest appearances from different YSL defendants. Oh, that's cute. Miss Sheila. Let's go back to that moment. I love WTF, y'all, and I feel like some stuff that happened took away from why we started WTF, right? So I'm sorry, y'all, and it's not like I'm sleepy. It's like, I don't know how to explain it. It's probably from me talking that's making me have to take these deep breaths and yawn and all of this. But anyway, Grandma Betty, whom I love, by the way, that live had to be probably the worst for me, y'all. It was probably you know what, Key? Thank you, Key. I think so for those of you guys that have like been following me for a while, I think y'all are used to how I act. But I think some people, I don't think they think it's me, but let me tell y'all, on that live in particular, y'all know I'm all for shits and giggles, okay? I'm all for shits and giggles, okay? But I think I've told y'all this story before. On that particular live, Libra girl, I do zone out because okay, let's talk about it. Let's talk about it, okay? Sometimes I want us to be politically correct. And and sometimes even I slip up, okay? Even I slip up. On that particular live, I knew Kayla was going to come on and talk to us about what happened in court, but there were things that just like threw me off, okay? First of all, she came on getting her makeup done. And like for me, I think it is distracting when we're doing any type of live and you got other stuff going on. So when she came out, not only that, we're gonna fast forward. Kayla texts, we knew we were doing the live. Remember, Miss J and I were already on live. And then Kayla texts, like, here's the link. So I'm a little annoyed because we had like 1,000 people in the live. And then Kayla was like, don't come to this one. And I'm like, oh my God. I think I was more concerned about people that were watching. Because people that were watching, I'm like, I didn't want to move them from one live to another one. So I was a little annoyed. But then when I joined the live, I saw that the young lady was waiting. So it made sense. So it made sense why we needed to come over there because there was someone waiting in the live. But I didn't know that. Okay. I did not know that the young lady was waiting. So when I saw it, I said, okay, this makes sense. Then after that, Miss Tyler was waiting. Okay. So I said, okay. So after I get over joining the live, then Kayla's getting her makeup done. And I'm like, okay, this is going to be distracting. So here we go. Not only was Kayla getting her makeup done, I was getting overstimulated because there were people in the background talking. So like, even when I was talking, I don't know if you guys could hear it, but even when I was talking, like I could hear people talking too. And so again, I'm worried about people that are watching and are they able to hear what I'm hearing? So I was like, okay, that was going on. That was the switching the live. Kayla was getting her makeup done. We joined on talking in the background. Then also after like not only just talking in the background, I knew Kayla was going to be mad, but I think I was more nervous. Like I didn't want her to say something crazy on that live because I knew she was going to be upset, but it seemed like she was really upset, like too upset to talk. And I was a little nervous, like, because I know that people screen grab our lives. And so I think I was just more so nervous about that. So when I was zoning out, I zoned out, honestly, because I was just like, I'm just not going to say anything. I was just like, this is not, listen, King. I said, this is not where I thought this live was going. And when she started going off, I was like, okay, so I'm just not going to say, anything. And so what I did was like, so I don't know if you guys use StreamYard, but when you're using StreamYard, Kayla gives us, if it's on Kayla's live, right? But Miss J and I also stream. So it's all one chat. But at the time, y'all, I wasn't thinking because Mel, they're live on law and crime. Hold on, I wasn't thinking just because I was already overwhelmed. So I just felt like, let me just do something. Let me go talk to my chat. So I went in my chat. And I'm trying to talk to y'all in the chat, forgetting that it's all one chat, right? And so when it clicked in my mind, it was all one chat. I think I zoned back in, and then I heard someone talking on the other live. And when I heard somebody talking, my first initial thought was, why in the hell are the police? Why are they running up in Kayla's house? What did Kayla not tell us? I said, what did Kayla not tell us? Because why the police running up in your house? You know? So I'm thinking like, damn, Kayla mama really telling the tea, right? I'm like, damn, you know? I said, Kayla mama really spilling it on the live, because how do we go through the police running in Kayla house? And y'all, and Miss Betty said something that made me say, is that Miss Betty? Kayla. I mean, not Kayla. Hold on, y'all. Look at these guys. Key. When I'm gonna have to go back and watch that live, because I can only imagine. Hold on, y'all. Why is Law and Crime live again? Hold on, y'all. I saw y'all saying Law and Crime was live, but are there more pleas?
Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of this trial, which should be filed. And any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th. The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd, so that you know what you don't have to worry about in terms of discovery. And we are looking at.
Okay, yeah, it looks like she's setting the calendar for everything, but y'all just don't understand, okay? Let me tell y'all. When she said, "Ma'am, I'm finna send you this text message," I'm like, it was already a lot on the live, okay? It was already a lot. It was already a lot going on the live. So when she said text message, I'm like, the hell you are finna send me a text message? Like, you know, we live. Like, y'all don't understand. We are live, okay? Thank you, D. We are live, y'all. Like, Key, I'm finna go back and watch it. Y'all, we are live, okay? So when she said, I'm finna send you this text message, you finna send me what? And what this said text message say? Because like we ain't discussed that off live, you know what I'm saying? Like we ain't discussed no text message, Kayla. Let me see what's in this text message first, okay? Like let me see what's in this text message before you have me. Because listen, y'all. Let me see what's in here, okay? So it was just like like I'm telling y'all know how y'all remember I said, hold up. Y'all, let me tell you. When Doug said, wait a minute. Okay, Tay, I'll play it. Baby, when Doug said that, okay, when she said something about them coming in her house, had me in the chat tell I know. Key, I was not seeing it. Listen, I think that's what people have to understand. Like, we're literally live, and I just kind of like to know what we're talking about on the live. One, because people misconstrue things all the time. And then two, like, don't drag me in mess I don't have to be in, okay? I be telling you all the time, like, oh, they moved it to February 24th. What key? That's what they said. Okay, we knew it was February 24th. Let me find it, y'all. Hold on just a second. It was me and Miss, like, cause y'all, we did like people. I think people, we did not know that was not, we didn't know that was finna happen. We didn't know all of that was finna happen, y'all. Did I stream it that day, y'all? I just said we were on my page. We didn't know all of that was gonna happen. I mean, we just didn't know. It was a shock. Girl, here we go. This
said I do stream.
Oh, okay. Don't
Go
play.
to somebody for
First of all, let me just say, the live just started. The live just started, and y'all gonna have to let me do something real quick. Let me, before we watch this, I'm gonna end this. I'm gonna end this stream, and then I'm gonna rewatch it. We'll do a reaction to it because I don't want all this stuff mixed in. I'm gonna have to already edit this video as is. So if you want to watch the reaction, I'm gonna end this stream and start another one because I'm about to watch it. I think it's only 30 minutes long. So I'm gonna first of all, y'all just started the live, and Kayla came on the live talking about I'm gonna need them to find something safe to do. Like, so y'all finna end this live. Because I'm already gonna have to edit the end part out, and then we're going to I'm gonna just start another stream on here. So if you want to watch this with us again, this is gonna be my first time rewatching it. This is gonna be my first time. So if you want to watch it, I'm gonna get out of here and then I'm gonna start it back, y'all. They said turn the money on. I am Miss Unpopular. Thank you. I'm gonna be right back.